Welcome back to the Insurance versus History podcast. I'm Meredith Brasher, and I'm excited to dive into more episodes where I examine how insurance has changed history. I have a bachelor's and master's degree in history, and for 20 years I worked in the insurance industry, underwriting liability exposures for everything from paranormal investigators to the world's top 500 companies. Do you want to know how history happened? Insurance can help. Without giving my age away entirely, I will admit I'm a child of the 80s. While I love artists like Howard Jones and Duran Duran, I also have a deep love of certain hair metal bands, specifically Cinderella, White Lion, and Def Leppard. I've been lucky enough to have seen several of my favorite 80s artists perform their greatest hits. It never occurred to me that something could go wrong during a concert and I might be in danger. But on February 2nd, 2003, more than 400 people who also loved the 1980s attended a concert at the Station Nightclub in West Warwick, Rhode Island. The band was Great White, a hair metal band with one memorable hit, Once Bitten, Twice Shy. The attendees probably didn't think about their safety when they bought tickets. But that night, something went wrong. A fire broke out at the concert, resulting in 100 deaths and 230 people injured. When bad things like this happen, insurance should respond. That's what it's there to do. But what if the people responsible don't have enough insurance to compensate those affected by the disaster? Well, then things get complicated. This is a story about how small decisions can result in tragedy, how fire spreads faster than you can imagine, and how the people who are responsible are sometimes not the people who are held accountable. I'm going to start this at the very beginning so you can see just how many small decisions resulted in tragedy. So, West Warwick, Rhode Island is a working-class town of about 30,000 people. In his book, Killer Show, lawyer John Barrylick describes it this way, quote, "If West Warwick were a car, it would be a 1957 Studebaker, functional in its day, but now well past its prime," unquote. The Station Nightclub was a local dive bar in West Warwick that had been around in some form since just after World War II. The wood frame building that housed the Station Nightclub was erected in 1946, but it had had several owners over the years and several businesses, mostly restaurants or bar-type operations. In 1971, there was a fire in the building that did significant damage, and as a result, the station sat empty until 1974, when the building was purchased by Raymond Villanova. He started operating an Italian restaurant called Papa Brillo's in the space, but by the 1980s, that business closed, and Villanova started renting the building to tenants through his property company, Triton Realty. The building was leased on an as-is basis, and the tenants were entirely responsible for maintaining the property through that lease. That meant that Villanova and Triton had zero responsibility for the safety of the venue. This is bad decision number one. In the 1990s, a tenant named Howard Julian operated a nightclub and concert venue called the Filling Station out of the building. This is bad decision number two, and that's because of two things that happened during this time. The first is the discovery that the fire damage from the fire in 1971 wasn't entirely mitigated. I mean, that's not his fault, to be sure. He wasn't the owner then, but an electrician working on the filling station commented on the ceiling space above the club, quote, "All the rafters were charcoaled. I put my hand on it. It was black," unquote. There's no indication that any action was taken as a result of this realization, so we know that the building itself still contained fire damage, some of which wasn't repaired. The second issue was that Julian decided to install some foam in the nightclub to dampen noise and reduce complaints from neighbors. He sourced this foam out of a dumpster, spray painted it black, and adhered it to the walls of the club and the area around the stage. There's no indication he understood or investigated the flammability of the products that he used. At this point, Julian's club was making no money for him, and maybe this is why he resorted to the foam of unknown origin, but as a result, Julian sold his operation to two brothers, Michael and Jeff Dudarian, in December 1999. It's not entirely clear why the Dadarian brothers wanted to buy a nightclub/concert venue. Jeff was a TV reporter for a Boston TV station, and Michael worked for a financial services company and dabbled in commercial property ownership. My notes when I was researching this said, quote, "Why did these two chuckleheads buy this club?" unquote, which gives you a pretty good idea of what we're talking about here. Neither brother had any experience owning and operating a nightclub or a concert venue, though they did inherit some of the prior operator's employees. The $3,500 a month lease from Triton Realty was on an as is basis, meaning that as part of the lease, the Dadarians took on the responsibility of maintaining the building. At the time of the transfer, the fire chief, the police chief, and a city building inspector reviewed the property. We don't know if the Dadarians had an independent inspector, but if they had, I would have expected them to bring it up in court, which I don't think happened. None of the documentation created by this transfer ever mentioned anything about existing fire damage or foam on the walls and ceiling, but the police chief did note that the Dadarians should get out ahead of future noise complaints and fix them if they wanted to be successful in this enterprise. Primarily, it seems like the main noise complaints came from a homeowner who lived within sight of the Station Nightclub. When the Dadarians went to talk with this homeowner, he suggested maybe they add soundproofing foam to the building. It just so happened that he worked for a company called American Foam. The Dadarians ordered 25 blocks of sound foam from American Foam for $580, and they attached it to the ceiling and the walls of the station on top of the existing foam from the 1990s. There's nothing on the invoice or any correspondence about this sound foam as to whether or not it was supposed to be non-flammable, and during the investigation afterwards, there was also no indication American Foam ever advised customers on the fire-resistant qualities of any foam they sold. The manager at the Station Nightclub spent a week gluing this foam to the walls and ceiling using probably flammable spray adhesive in July 2000. Adding this new foam was bad decision number 3. Between the time that the Dadarians purchased the building and February 2nd, 2003, when the fire happened, the local fire inspector had been out to the property at least 3 times for routine inspections. In addition, as part of the Dadarians' insurance program, risk control specialists hired by the insurance companies had been out to the property to look it over as well. While the fire inspection did mention items that needed mitigation in the reports, specifically a door by the stage that opened inward and not outward, and a curtain near the stage that was determined to be flammable, none of the inspections mentioned the foam on the walls and the ceiling, and frankly, on some of the doors, or prior building damage that still existed from the earlier fire. This is bad decision number 4. The 5th bad decision involved the Dadarians' general cheapness when it came to their business ventures. For example, they also owned a local gas station, and employees at both the gas station and the Station Nightclub were often paid under the table. Sometimes employees would be paid some money via paycheck and some money under the table, a move apparently to reduce the Dadarians' tax burden and their required payments into unemployment insurance, among other things. The brothers got a reputation for not paying bands that played the station, particularly local bands. At one point, they even hired an artist to paint a mural of famous musicians on the outside of the building and then refused to pay what they had agreed to pay. The muralist left the work unfinished. In the case of the Station Nightclub building itself, the Dadarians were responsible for maintaining the fire system at the club installed by Howard Julian in 2000, and they stopped paying the company contracted to maintain it, which was a whopping $65 fee. The alarm company sent a letter explaining this to the West Warwick Fire Prevention Office in December 2002, just 2 months before the fire. But nothing was done by West Warwick to address this, and no other fire prevention company was hired by the Dadarians. This fire system that was installed did not include a sprinkler system because local and state fire codes included a grandfather clause stating that Older buildings did not need sprinkler systems if the building met certain qualifications, and the station met those qualifications. The night of February 2nd, 2003, the Station Nightclub was host to the 1980s hair band Great White. The nightclub often featured 80s hard rock bands like Wasp, Warrant, and a whole host of hard rock tribute bands with names like Shirley Temple of Doom or Dirty Deeds. Great White wasn't as great as it was in the 1980s. The lead singer was the only remaining permanent member in the band, now named legally Jack Russell's Great White, and the rest of the musicians weren't even official replacement band members. They were contractors hired to play with the lead singer. One of these contract members, Mark Kendall, was the guitar player back when Great White was initially established, but he was now only a contractor and not officially a band member. They were on an 18-city tour of venues of 500 people or less, and they were determined to put on a great show, including using pyrotechnics on stage. The pyrotechnics were new to Great White. Their band manager, Dan Biacelli, previously managed a U.S. tour for Wasp, a band that loved pyrotechnics. Biacelli wasn't formally trained or licensed in the use of pyrotechnics. The company that sold Biacelli these pyrotechnics did know that he was not licensed, and at one time suggested he switch from pyrotechnics to less flammable and more expensive special effects products like fog machines or cannons that shoot confetti. But at no time did the company or the salesperson stop selling to Biacelli because he was unlicensed to use the product. That's mistake number 6. Rhode Island, like most places in the U.S., requires that anyone handling pyrotechnics have a license to do so, in addition to legal requirements to carry insurance for the exposure and obtaining permits from the town where the pyrotechnics were used. If you guessed that Biacelli did none of this, well, you'd be right. Biacelli also didn't carry a fire extinguisher with him or even ask about fire extinguishers at venues. The closest fire extinguisher at the station was almost 60 feet from the stage. The day of the concert, Biacelli assembled 4 gerbs on the station's stage. That's gerbs, as in Gerbs, but pronounced gerbs. And if you've never heard that word, well, neither had I. But if you've ever used a sparkler or a fountain firework, well, these are bigger professional versions of those pyrotechnics. Gerbs shoot sparks 15 feet high, lasting about 15 seconds. Some people call them cool sparks because if you put your hand in the flames, you won't burn your hand because the moisture in your skin extinguishes the small metallic flecks put off by the gerb. But if the flecks meet flammable material, they will burn. And based on the product that Biacelli was using and the station's layout, it was pretty much a given that they would hit something flammable. The station's ceilings were 12 feet high, and the far right and far left gerbs Biacelli set up, pointed at a 45-degree angle towards the wall, had less than 10 feet of clearance. Sparks would shoot up at least 15 feet. You don't have to be good at math here to figure it out. And the walls and ceilings the gerbs were aimed at were covered with foam, in some cases 2 layers of foam. There is still some disagreement over whether or not the Dodarians knew that Great White was going to use pyrotechnics in their show. When Howard Julian ran his business out of the building, bands, including Wasp, who was managed by Dan Biacelli at the time, used pyrotechnics inside the facility. The Dodarians insisted that they did not approve pyrotechnics. Great White and Biacelli argued that they had permission. Other local bands also claimed to have used pyrotechnics during the time the Dodarians owned the facility. Whatever the truth is, I can't understand why someone working that day at the station wouldn't have asked about what Dan Biacelli was setting up on stage, and so the idea that no one knew Biacelli was going to set up pyrotechnics is, frankly, ridiculous. Somewhere between 350 and 450 concert goers were inside the venue before the concert, and this is also a point of contention that has never been satisfactorily solved. Over the years, the fire marshal approved higher and higher maximum occupancy counts for the building, as tables and chairs and pool tables were removed and frankly, as the tenants, especially Julian and the Dodarians, aggressively argued for higher limits. At the time of the fire, the maximum legal capacity was about 400 people. We know they sold out of official tickets and were just waving people inside after taking their money. That suggests more people than what would have been legally allowed. But it also appears that after the fire, people claimed to be at the venue who actually weren't. Maybe they were looking for money or their 15 minutes of fame, so that number is uncertain. Anyway, after 11 p.m., after two opening acts, Michael Gonsalves, a DJ from a local Providence radio station, WHJY, hyped up the crowd before Great White took the stage. The radio station had been promoting the concert for weeks. Budweiser representatives were handing out beer to patrons as part of a promotion as well. At 11:05, Great White started playing, and almost immediately, Biacelli set off the gerbs on the stage. The two end gerbs went off, and their sparks immediately set the foam on either side of the stage aflame. Sparks from the gerbs that were pointed towards the ceiling ignited the foam above the stage. While some patrons did leave immediately after the ignition of the walls, most concert goers seemed to think it was either part of the show or they just didn't know what to do. I mean, the band kept playing, though about 30 seconds later they stopped, and lead singer Jack Russell looked at the flames and made this prophetic understatement. Wow, that's not good. 40 seconds after the ignition of the foam, the fire alarm went off, but it wasn't connected directly to the fire department, so someone had to call 911 themselves to report the fire. I think they were lucky it went off at all, given they'd stopped paying for its maintenance. By this time, bright yellow flames were consuming foam on the left and right sides of the stage, as well as the ceiling over the stage. At 11:07, just 1 minute after the gerbs were ignited, the flames on the wall were growing larger, and thick, toxic black smoke started to fill the venue. The smoke was so dense that it appeared to guests as if the lights in the venue had been turned off. Even worse, some of the foam was producing hydrogen cyanide, a deadly gas. At this point, people panicked and tried to leave. There were only a handful of exits, and most people tried to leave through the front door, which was separated from the club by a narrow hallway a little over 2 feet wide. The floor in the front of the door sloped down, and in the rush, someone fell, beginning a chain reaction pileup of people partly inside and partly outside the burning venue. Those who could not get out the front door and weren't stuck in the pile broke windows in the building to get out or tried to access the other exit doors. But a lot of people never escaped, overtaken by heat or deadly fumes or unable to find an exit or break open a window. Those who did escape found themselves outside in the below freezing cold, though some people were able to use the snow on the ground to extinguish people who were literally on fire. The building was completely engulfed in flames by 11:12, only 6 minutes after the gerbs were set off. The first fire engine got to the station at 11:13. Firefighters on the scene numbered in the hundreds, some 34 rescue units and 23 ambulances. Even with that type of manpower, the fire was uncontrollable. The firefighters fought the flames for 30 minutes before the building started to collapse, and it was too dangerous for them to continue. The intense heat of the fire, which measured 1,800 degrees in the area around the stage, as well as the toxic smoke created by the flames and the foam, meant that if you weren't out of the building within the first minute of the fire, you died. Well, unless you were in that pile of people in the doorway, then you had a very, very slim chance of survival. In that case, a handful of people were removed successfully alive, though severely burned, from that location. Some, even after the fire was extinguished. But the vast majority of people in that crush perished, either from flame or smoke or suffocation. The tragedy left 100 people dead and 230 people injured, many of whom had life-changing injuries. It was the fourth deadliest nightclub fire in U.S. history. 64 children under 18 lost one or both parents. While the majority of the dead and injured were concert goers, they weren't the only people who died. Ty Longley Great White's drummer, two members and one wife of one of the local opening acts called Fathead, WHJY DJ Mike Dr. Metal Gonsalves, and four employees of the Station Nightclub also died. Wood frame buildings do burn. That's true. But this fire was hotter, faster, and more toxic than anyone expected, and the damage was catastrophic to those people inside the building. Something had gone terribly wrong, and someone was going to pay. But who do you blame? And was it a crime? Patrick Lynch, the Rhode Island Attorney General, took it to the grand jury. On December 9th, 2003, the grand jury suggested indictments against Dan Biacelli and the Didarian brothers. Several of the people brought before the grand jury were not indicted, specifically the West Warwick fire marshal and the lead singer of Great White, Jack Russell. This made a lot of survivors very unhappy. However, the fire marshal was subject to a Rhode Island statute that made him immune from prosecution, and I'll touch on that later. And Jack Russell, well, that one's still up for debate. But justice was fleeting. There were no trials. Biacelli took responsibility for his part in the event and pled guilty to 100 counts of involuntary manslaughter in 2006, 4 years after the fire. He was sentenced to 15 years in prison and served 4. The Didarian brothers pled no contest in 2006, meaning they admitted no fault and they would not have to face trial either. Michael got 15 years and served 4, even though he wasn't even in town when the fire happened. Jeff, who was at the station that night, only got 500 hours of community service and no jail time. Apparently, Michael volunteered for the jail time because Jeff had young kids. For the people who had lost family members and the people who had been seriously injured, this was cold comfort and didn't begin to address the issues they were facing: huge medical bills, changed lives, and devastating personal loss. And here's where insurance gets involved. You probably have already guessed that this tragedy led to lawsuits. You can also imagine that personal injury lawyers were circling the victims almost as soon as the fire died out, if not before. Who do you hold accountable for this tragedy, and how do you hold them accountable financially? To me, and probably everyone else listening, some obvious people should be held responsible financially. Dan Biacelli, the tour manager who set up and lit the pyrotechnics, Jack Russell, who wanted the pyrotechnics in the first place, and the Didarians, whether or not they knew or approved of the pyrotechnics. Either way, they were guilty of ignoring obvious safety issues. The Didarians' argument, of course, was that they didn't know and someone should have told them that the foam was a fire hazard. Someone like the fire inspectors or the insurance inspectors. But the Didarians did stop paying their alarm company, so clearly they didn't put safety at the top of their list. And it came out during the discovery process for these lawsuits that before the fire, the Didarians even offered a job to a licensed pyrotechnic technician and then rescinded that offer when the technician insisted on getting permits and insurance as a condition of his employment. Now, mind you, even if everyone had done everything right and the fire still happened, it was a given that they were going to be sued because of the loss of life and injuries inflicted by the fire. I sure hope they have insurance to pay the inevitable financial penalty, right? It's more complicated than that. There were 100 deaths, 230 people injured, and some people with medical bills in the millions of dollars, with lifetime medical bills looming. Even if you paid out $1 million for each person who died, just that, you're still talking about $100 million in potential lawsuits right there. And what insurance pays? In these types of situations, when a third party who is not part of the insurance contract is injured, aka the concert attendees in this instance, the insurance that responds is something called general liability insurance. My specialty. How appropriate. You may have guessed that the insurance that Biacelli, the Didarians, and Jack Russell carried was not going to be enough to compensate the people who were injured or killed that night, and you'd be right. Great White carried pretty much the minimum general liability insurance just to be able to tour. Well, to be precise, Jack Russell carried $1 million of liability insurance. The band members themselves were just hired musicians of Great White. Any negligence on their part would probably be covered by Jack Russell's insurance, assuming they had some kind of contract that spelled that out. But honestly, even without, they had a good legal argument that any lawsuits directed at them should be defended by Jack Russell's insurance. Dan Biacelli was acting as Great White's tour manager, meaning that Great White, aka Jack Russell, probably had a duty to defend him using their insurance program as well. Michael and Jeff Dodarian, the club owners, well, you would have expected them to carry insurance for the Station Nightclub, but how much? Well, for a venue of this size, I would expect they probably purchased a $1 million liability policy. Sometimes bars and restaurants buy something called a combined liability and liquor liability policy with a $1 million shared limit, meaning that either type of claim, liquor liability or general liability, would reduce the limit of insurance remaining available. I don't know what type of policy they had, if it was just GL or liquor and GL combined. Beyond that, the Dodarians could have carried an umbrella policy, a policy that provides additional limits above the general liability or GL and liquor liability combined. But the maximum insurance I would expect someone like this, like liability for a small nightclub to carry, would be about $10 million max. So if everything was perfect, that's probably a $1 million limit for Great White, no separate insurance for Biacelli, and maybe $11 million for the club owners. It was $12 million total. And that wasn't going to go very far spread out between the injured and the families of the people who died. That's like 36 grand a person, not including personal injury attorney fees. And here's where it gets a bit tricky. Is the goal actually to hold people accountable? Or is the goal to get the maximum amount of money you can for your client and, by extension, you as the attorney for your contingency fee? In this situation, as a personal injury attorney, that means you have to get creative to find compensation for your clients. You might be thinking, okay, so you've got hundreds of claimants suing about the same thing. So this would be a class action lawsuit, right? Well, no. While this did involve a lot of people suing about the same cause of injury, in a class action lawsuit, a handful or even one person sues on behalf of everyone injured using one law firm to represent them. The lawsuit for the station fire was something called a mass tort, not class action. A mass tort lawsuit involves a smaller group of people than typically included in a class action lawsuit. Every individual suing is included in the lawsuit, and everyone has their own lawyers. Those lawyers have to work together for their claimants through something called a steering committee. While there were some people who sued separately from this mass tort action, 306 people ended up part of the mass tort group here. The mass tort does provide some advantages. You can share discovery. You only have to interview witnesses once rather than every single lawyer interviewing every single witness. And the costs of the lawsuit are shared, which is great for the lawyers. Evidence gathering on this case cost them over $2 million, for example. And for this case in particular, where the people most responsible had very little money or insurance to contribute to the final settlement or verdict, having the lawyers work together meant they could brainstorm ways to bring other possible defendants, well, hopefully with more money, into the lawsuit. And they did. Imagine you're a personal injury attorney representing 306 victims of the Station Nightclub fire. Who can you sue? How wide a net can you cast? What reasons can you give for suing them? We'll start with the obvious. Jack Russell, Dan Biacelli, the Dodarians. We definitely sue them. Well, who next? Well, how about the owners of the building? Triton Realty and Raymond Villanova? I mean, they could have made the building safer, right? What about the people who sold the pyrotechnics to Dan Biacelli knowing he was unlicensed? What about the companies who made the pyrotechnics themselves? Could you argue that the pyrotechnics were inherently dangerous? How about Howard Julian, the man who installed dumpster-sourced foam in the 1990s? Well, how about the company that sold the Dodarians the foam they installed on top of Howard Julian's foam? What about the companies who made the foam? Both kinds. What about the fire inspector who never noticed or mentioned the foam during multiple inspections of the property? And what about the inspection companies that inspected the club on behalf of the insurance companies? Should they have seen the foam and notified someone? Can we sue them? All of those to me are pretty obvious, though at least one of those was going to be a very hard sell. And the lawyers did sue all of these entities and people. But if you have to expand the net to make sure you've sued anyone even remotely connected, what less obvious entities and people could you sue? For example, what about some of the other companies that were in the club that night? The local radio station had a DJ hyping up the crowd before the concert. Could you sue them? What about the company that owns the local radio company? The local Budweiser distributor was on site distributing beer as part of a promotion. Could you sue them? Or even better, sue Anheuser-Busch, the parent company of Budweiser. There was a local TV cameraman there that night. Jeff Dadarian had asked him to come and take some stock footage of the club to use later in an unrelated story he was planning to cover back at the TV station. Could we sue the TV station or the cameraman? What about the parent company of that TV station? Maybe you just thought to yourself, well, come on, really? The radio station, a TV station, and a beer company? I mean, they might have been there, but they certainly weren't responsible for the fire. Wait, are the lawyers targeting them just because they have a lot of money? I mean, Clear Channel, who owned the radio station, reported a revenue in 2002 of $1.5 billion. Anheuser-Busch, who owns the Budweiser brand, had a reported 2002 revenue of $57 billion. The company that owned the TV station, Lynn TV, had revenues in the hundreds of millions of dollars. Well, let's just say this is not an uncommon tactic by personal injury attorneys. If you aren't in the insurance industry, you may have heard the term deep pockets before, though you might not have a really good idea of what exactly it means. If you are in the industry, the term deep pockets is a term you should know. And if you come from the general liability world like I do, it's a term you should know really well. Deep pockets basically means that someone has a lot of financial resources or wealth. That makes sense. From a legal standpoint, it also suggests that the deep pocket itself is sued because of the amount of wealth it has, rather than the amount of responsibility it has. So, attorneys went after not just those people who might have been morally responsible, like Biacelli and the Dadarians and Jack Russell, but also those people and entities who were somehow connected and had a lot of money. And by money in this situation, well, we mean those people and organizations with a lot of insurance coverage. You can be a deep pocket because you have a lot of company revenue without having a lot of insurance coverage. Tech companies are often a great example of this. Don't ask me why I know this. Just trust me here. But generally, the deep pockets that get raided in these types of lawsuits are the insurance companies' pockets via insurance policy limits written for big companies. And generally, big consumer product companies have big limits. Speaking as an underwriter, while I understand the plaintiff attorney's position on going after deep pocketed defendants, I have issues. I'm about to sound very capitalist here, which is in direct contrast to my last episode on the slave trade and, frankly, a lot of my other episodes, but I cannot underwrite this. A liability underwriter's job is to figure out what can go wrong with any given risk to provide coverage and charge premiums accordingly. I exclude the things I don't want to cover and price, meaning I charge, for the things I do want to cover. And while this is always a bit of a crapshoot anyway, as insurance covers unexpected acts as the entire principle of the product, it is nearly impossible to price for or even determine the potential size of deep pocket claims. I mean, not surprising fact, awards keep going up every year. The way to avoid a deep pocket claim is just to refuse to write high value companies, which come with high value premiums, even without taking into consideration what might be charged for deep pocket claims. No insurance company manager or CEO is saying, give up all that premium money on the chance your risk might end up paying an enormous claim where they have very little culpability just because they had the most insurance. You might be able to protect yourself as an underwriter by staying low in the tower, like only insuring the first 10 million in limits, or being very high in the tower, like insuring above 100 million in limits. But again, you cannot underwrite to this. The deep pocket, after all, isn't the company itself, it's the insurance company and the insurance market that allowed these companies to take out very large limits. I mean, who are we punishing here? It's not the consumer companies, for sure. Having said that, you as an underwriter will still be held responsible for writing a risk with an immense claim, and you might lose your job. I can say from personal experience that I have written accounts with claims just like these, and those experiences have not been positive, though I did keep my job. In retrospect, would I have done it differently? Honestly, no. I didn't think anyone would have predicted the deep pocket on these particular risks. And maybe you'll feel that way too about some of these companies that were sued as part of this lawsuit. For the companies that were sued, their insurance responded. But if you've listened to more of my episodes, you will also remember that insurance isn't there to fight your battles, and insurance isn't there to win. The insurance company's goal is to spend as little of its money as possible. And with liability claims, the limit of liability typically does not include defense costs. Those are the lawyers. Those costs are outside the limit and do not reduce the limit of insurance available. It's extra. So even if an insurance company thinks it could beat a claim in court, they have to take into consideration how much money it would have to pay to do that. I mean, legal fees can be enormous, especially if you hire high priced lawyers like, say, David Boyes. So it may be cheaper to just pay the claim, even though you think you could win in court. Not to mention, going to court might mean opening doors to other lawsuits if one of these companies that were only nominally involved lost. And I mean, frankly, it made everybody look bad considering the level of sympathy the plaintiffs were getting in the court of public opinion. In the end, all the people and companies named in the suit decided it was better to settle than to fight. And settle they did for a total of, and get ready for this, $176 million in 2008. This number was not evenly distributed, and it is a great example of deep pockets in action. I'm going to read the amounts out here listed from largest to smallest. First, Lynn Television Corporation, $30 million paid out by their insurer. This was the company that owned the TV station that employed Jeffrey Dodarian and the cameraman Dodarian had brought to the club that night to film background footage for a later planned story. That story was on safety in public places. So, the irony. What did the plaintiff's attorneys think was the connection? Well, the cameraman continued to film after the fire started, though he was one of the first people to exit the building. He then set up the camera outside the building and continued filming, eventually calling his bosses to tell them that they needed to get down to the Station Nightclub immediately as it was about to become a big story. The cameraman argued he left the camera running and helped evacuate people, but honestly, that was never definitively proven. The lawyers argued his filming outside the club, quote, impeded the crowd's exit through the front door, unquote. This was not a good look for Lynn Television, though they had hired fancy lawyer Charles Chip Babcock to defend them. This is the first mention of Babcock on my podcast, though I expect to see him again. For example, he defended Oprah Winfrey in that whole mad cow beef thing in the late 1990s. Hi, Chip. Second, Sealed Air, $25 million. Sealed Air was the company most likely to have manufactured the foam that Howard Julian pulled out of a dumpster and attached to the walls of the club in the 90s. During the investigation of the fire, it was revealed that while the foam that the Dodarians attached was flammable, it was actually the Julian foam behind it that ramped up the fire, both the heat and the toxic smoke. During fire testing, the head of the testing company said he had, quote, never seen a room flash over or become more flame intense, unquote. I won't get into too many details because John Berlick does a great job of explaining all of this in his book Killer Show, but the process the lawyers used to try and figure out the true manufacturer of the foam is fascinating. Many different companies make the same types of foams, and it's not like the stuff is stamped. Once it's out of the container it's shipped in, it's very hard to pin down who made it. Insurance paid the 30 million, and I'm assuming that was probably all the insurance Sealed Air had. Clear Channel Broadcasting, $22 million. Clear Channel owned the local radio station, and the lawyers argued that the radio station's involvement in the concert constituted approval or sponsorship of the concert. As a result, they had some responsibility for safety at the venue. Clear Channel could have tried to fight it, but I think they were wisely very wary of setting any precedent if they lost. Would that mean they could be sued if they played a commercial for a company that was then named in a lawsuit? Did playing the commercial create a responsibility on the part of Clear Channel? Insurance paid this as well, though I doubt 22 million was the limit of their insurance tower. Leggett and Platt, $18.2 million. So this surprised me because I know this company is a furniture manufacturer for home furniture. We have a Leggett and Platt frame recliner in our living room. The frame is indestructible, though the upholstery could use some refreshing, but that's more of a we have a lot of dogs thing than a bad product thing. Feel free to sponsor me, Leggett and Platt. I will take your money. But Leggett and Platt also manufactured foam and either sold or distributed foam to American Foam, though there was no proof that Leggett and Platt manufactured the foam that was sold to the Dodarians. Unlike the foam that Julian used in the club, the foam that the Dodarians used was entirely consumed by the fire, and there were no leftover samples to test. The lawyers recognized that and spread their net wide, hoping that manufacturers of the same types of foam would just pony up. In the case of Leggett and Platt, their insurance paid out $18.2 million. Revenues alone in 2002 for Leggett and Platt were in the range of $4.1 billion, so I can say safely this was a drop in the bucket for their insurance tower. McLaughlin and Moran, $16 million. This was the Anheuser-Busch distributor who was handing out beer at the event for the promotion. To be clear, it was really McLaughlin and Moran's promotion separate from the big corporate Anheuser-Busch. Distributors of Anheuser-Busch are completely separate companies and share no ownership with Anheuser-Busch, and I'm sure that Anheuser-Busch encouraged McLaughlin and Moran to settle. There probably was some contract language in the distributorship agreement that gave Anheuser-Busch access to McLaughlin and Moran's insurance coverage if there wasn't an endorsement to the insurance policy itself. This was not M&M's entire insurance tower, most likely the GL umbrella and first Exis layer, I'm guessing. While I am again dubious about the legal argument, I think this company and by extension Anheuser, who shows up way down this list, they all got off easier than they could have. General Foam, $11.25 million. This was another foam manufacturer. While there are a bunch of foam manufacturers on this list, this is a much smaller company than Leggett or Sealed Air, but even so, while this is a lot of money, the insurance company probably gambled they were making the right decision to settle and get out before they spent any more defense money. American Foam, $6.3 million. This was the company that sold the sound foam to the Dodarians, and it was a safe bet they were going to pay a lot. I think that the lawyers had a good argument here that American Foam had some responsibility to understand their customers and provide foam that was fit for purpose and safe for use in a venue where people regularly smoked and which had no sprinkler system, pyrotechnics notwithstanding. $5 million of this settlement came from insurance. Another $1.3 million came from the estate of the deceased founder of the company, who was worth about $18 million. So why did a deceased individual, get tagged here? Well, the lawyers had named both American Foam and the owner of American Foam in the lawsuit. The owner had died in 2006, so after the fire, but before the lawsuits were settled. I suspect American Foam only had $5 million in limits, which, I think they should have had more, but maybe they figured the manufacturers who supplied them would step in the case of any products lawsuit. This wasn't really a products lawsuit, so it didn't really work for them here. At the minimum, American Foam should have had $10 million in limits, and I'm guessing if they had, the estate wouldn't have coughed up anything. Considering that the foam in question netted a measly $580 for American Foam, this was pretty awful. High Tech, Special Effects, and Lunatech, $6 million combined. Lunatech was the manufacturer of the pyrotechnic products used at the station, and High Tech was the distributor who sold the product to Biacelli. Lunatech had no assets at the point of the settlement as they had just lost their ATF license, partly due to the events of the station fire and their involvement, and they only had $1 million insurance policy left. High Tech also had $1 million insurance policy, and together they had purchased a $4 million umbrella policy that provided coverage for both companies. The lawyers argued that both companies had done a poor job of informing buyers about the danger of their products, and the loss of the ATF license wasn't a good look either. Anheuser-Busch is next. They paid out $5 million through their insurance carrier. I think this was a smart move on their part. They did not want to go to court and set a precedent that Anheuser-Busch had any responsibility to ensure the safety of any place where Anheuser-Busch products were sold or consumed. Can you imagine the lawsuits if that happened? Polar Industries, combined with Home Depot, paid out a total of $5 million, though it's unclear how it was distributed between the two companies. My guess, it was all Polar, and Home Depot required Polar to defend them. Polar was an insulation manufacturer, not a foam manufacturer. The lawyers argued that Polar's product, which was in the ceiling of the area above the drummer, was defective and dangerous. Home Depot was the entity that sold the insulation to the public, though I don't think it was ever proven that they sold that insulation to anyone at the station. I'm sure Home Depot encouraged Polar to settle here for obvious reasons. The town of West Warwick, Rhode Island paid $10 million. This was a settlement based on the lawyer's argument that the fire inspector, who was paid by West Warwick, did not do his job adequately by not noticing or testing the foam that covered the ceiling, walls, and some doors at the Station Nightclub. They also argued that a police officer who was providing security at the club, while acting in his employment as a police officer, not moonlighting, for those GL people listening in who will know why I mention this, that the police officer was also negligent. The town had a $4 million liability policy, which suggests to me that Rhode Island has pretty good tort reform, meaning that the caps on what government entities can be sued for are pretty low. But all the same, I'm sure some of this was frankly goodwill. Politicians got a politician, y'all. News reports said the town would have to borrow that $6 million insurance wouldn't pay from somewhere. That means taxpayers. The state of Rhode Island also paid out $10 million. This is mostly because the West Warwick fire inspector was also considered both a town fire inspector and a state fire inspector, even though he was paid by the town. There's a whole legal discussion about whether a servant can serve two masters, and the answer in this case was yeah. They probably could have chosen to fight this one, as the U.S. district judge overseeing the lawsuit made some noises in their direction that suggested the state didn't have any liability here, which I'll comment on in a minute. But honestly, this was a smart goodwill move on the part of the state, who probably did have this much insurance on hand. Triton Realty paid out $5 million, and I bet you're surprised to see them so far down the list. I think that their as-is lease was probably a big issue here. They had some responsibility to know how their building was being maintained and what was being added to the building that might affect its safety and, frankly, its flammability. But they also probably didn't have a lot of insurance, given the fact that they pushed all the maintenance of the building onto their lessees. The claims against Triton are pretty entertaining, but one thing I will mention is that their lawyer claimed that no one at Triton knew that the station was a nightclub. Yeah, right. I'm sure that also explains why Triton moved a lot of its property into different LLCs after the fire, and why Raymond Villanova changed the deed on his house to his wife's name. I'm not saying anything. Celotex, $1.5 million. Celotex was a company that manufactured a fire-resistant soundproofing board. These boards had been installed on the stage near the drummer, and while they did not contribute to the fire, well, the lawyers argued the product also hadn't stopped or slowed it down either. I mean, to me, this is a bit of a stretch, but their insurance paid out $1.5 million, and anyone who knows the name Celotex knows that this was a bargain compared to the claims they paid out and are still paying out due to their product's involvement in the Grenfell Tower fire in West London, along with the money they put into a trust they had to establish in the late 90s to handle product-related asbestos claims. If You are an insurance professional well versed in the Grenfell Tower fire, and you don't want to come on a podcast to talk about it. Send me an email, please. Next, New England Custom Alarm, the small company that provided fire protection monitoring and maintenance at the station until the Dodarians quit paying them, ended up paying out $1 million. They were on the hook simply because they installed those fire alarms in the building, though the lawyers alleged they did not install smoke detectors in the HVAC vents, something that building codes required. I'd love to understand this further because if it's true, I mean, that is definitely a problem. However, I am sure this was the limit of their liability insurance, who basically just handed a check over to get out of a claim. But as an underwriter, this cheeses me off. Yes, he installed the fire alarms. What was he supposed to do when they stopped paying the contract? Come back and take those fire alarms back? I mean, if he'd done that, he'd have been on the hook too for removing them. There was just no winning here. But it feels quite unfair that his insurance paid more than the Dodarian's insurance. Still to come. Jack Russell Touring Incorporated paid out $1 million, an amount that also included defending Dan Biacelli and the record label. Jack Russell's insurance company, St. Paul Insurance, wisely decided to just pay out the limit rather than trying to defend him, which would have cost more than $1 million and again wouldn't have reduced the limit of insurance. By paying their limit, they were done, out of the discussion. Should he have had more insurance? Well, for a tour of this size and given that Jack Russell appeared to be broke besides, I mean, honestly, no. JBL Incorporated's insurance paid out $815,000. And you might ask, ah, as I did, because my first thought was, isn't JBL a speaker manufacturer? Well, yes, and the lawyers argued that the speakers that Great White used during the concert contained flammable foam. I mean, JBL had a pretty good argument that any foam in their speakers certainly didn't contribute to the fire in a significant way, but again, the insurance company probably looked at the potential defense costs and said, here, have our $815,000. It's a bargain. Durco LLC, which was the company that Jeffrey and Michael Dodarian owned, that then owned the Station Nightclub business, their insurance paid out $813,000. I'm going to come back to this. You can be mad too. I won't blame you. ABC Bus and Superstar Services LLC. This was the company that leased the tour bus to Great White, and they paid out $500,000. Why were they in there? Because Dan Biacelli brought pyrotechnics on the bus and then transported them across state lines. There are legal requirements to transport fireworks on both a state and federal level, and this transit broke both. The lawyers argued the bus companies should have known about this. The bus companies, of course, argued that they were just leased passenger transport vehicles and had no responsibility to determine the legality of anything transported, and that the bus drivers had no idea the fireworks were on board. The transit companies had a point, but it's likely their insurance just wanted to exit the situation without having to spend a fortune on defending the claim. As a result, the insurance ponied up $500,000. I'd have done this too, just FYI. The legal fees alone defending this would have been more than $1 million. William T. Burnett and Company paid $300,000. This was a foam manufacturer, and I'm sure their insurance said, "Oh, just take this, please." FFNC, which was another foam manufacturer, also ponied up $250,000. I suspect they had the same conversation with their lawyers. Essex Insurance Company paid out $100,000. Wait, what? You mean not paid out for some other entity above, but like paid out themselves? Yep. Why? Oh, I'll come back to that. Same with underwriters at Lloyd's. I mean, they paid out $100,000 as well. Bizarre. Next, we have the various insurance agents who supplied insurance for the Dodarians or other people, a company called Surplex Underwriters who acted as an MGA, managing general agent, which means they're an insurance agent who also has what we call the power of the pen, the ability to quote, bind, and issue insurance policies for certain carriers under certain circumstances without notifying the carrier immediately. Surplex paid $35,000. Another MGA called Gresham and Associates paid $10,000. Another MGA, Anchor Solutions, $10,000. VB Gifford, an insurance agency, paid $7,500. All of this was likely paid out by their various errors and omissions insurance policies, I am sure. And finally, at the very bottom, Howard Julian, who paid a measly $3,000. I'm not surprised to see him down here, even though he installed foam he found in a dumpster on the walls of the Station Nightclub in 1999, and he had some culpability for this, but he had no money and probably no insurance. You can't squeeze water from a stone. So, if you had no idea what deep pockets were or how they worked, this is an excellent example. The people in companies who had the most responsibility, I mean, in my opinion, paid very little, and companies with far less responsibility paid the lion's share. But you know that's not the end of the story, right? And you know that there must have been some interesting stuff when it came to the insurance policies, and you would be right. There were a couple of things came to light during this process I thought were interesting from an insurance standpoint. First, I probably should talk about the Dodarians. They were never going to end up paying out a lot of money because, as I said, they likely only had an insurance policy in the $1 million range, but it turned out they didn't even have that. The GL policy was written by Essex Insurance for their company Durco LLC, and the insurance policy contributed just $813,000 to the total settlement. That's because the policy had already paid out $186,000 in medical bills for station fire victims as part of the MedPay section of the Essex policy. MedPay, this is some real deep dive insurance nerd stuff, and maybe someday I'll just do an episode on MedPay. But outside of the insurance policy itself, the mass tort lawyers could go after the personal funds of Jeffrey and Michael to see if they could get additional compensation, but Jeffrey didn't have a lot of money. You'd be surprised at how little some people in entertainment make. His brother Michael had more money. At one point, his net worth was in the $3 million range, but that probably included his house and his retirement accounts, maybe even the Cessna that he owned. But either the Dodarians or their lawyers knew that they could keep their funds in the case of a lawsuit if they declared personal bankruptcy. And that's what they did in 2005. In the list of assets, the Cessna is conspicuously absent. Did he ever own it? Had he already sold it to pay their criminal defense lawyers? Who knows? It's a mystery. While their decision to file bankruptcy did save the Dodarians from losing the money they had left, I can't give them too much credit for being insurance savvy because they were not insurance savvy. First of all, they cheaped out on that liability policy. I mean, they should have had at least a $5 million umbrella. Smarter still would have been a $10 million umbrella, and I suspect most agents would agree with me. Was this a decision of the Dodarians to save money or lack of knowledge? I tend to side with people who think this was deliberate because this wasn't the only insurance policy they cheaped out on. And this became very clear when people who worked at the Station Nightclub, people who worked for the Dodarians, tried to get some kind of compensation for the injuries they sustained while working at the station that night. And of course, when the families of the 4 people who died while working for the Dodarians tried to get some compensation as well. Now, since these people were injured or died in the course of employment while they were working, these claims for medical care and death benefits should have been covered by the Dodarians' workers' compensation coverage. But the Dodarians didn't have workers' compensation coverage for the Station Nightclub, like, at all. Well, they did have it for their Shell gas station in West Warwick, probably because it was required by Shell. The basic idea of workers' compensation is that by having it, the employer is protected from lawsuits by their employees. When you accept workers' compensation benefits as an employee, you forego your right to sue your employer. This is extremely, extremely simplified. I mean, there are ways you can sue, and I suspect even if workers' compensation had paid out here, the lawyers would probably have tried a workaround. But even worse, workers' compensation is a required insurance coverage for businesses in almost every state in the United States. It is illegal to go without it. I should note there are some places, like Texas, which have passed legal workarounds in certain circumstances that allow employers to go without workers' compensation. Don't get me started. That's a whole episode with a lot of cursing from me. It's also why so much work from these tech disruption companies like Uber and DoorDash is considered contract. The only things I think they disrupt are the workers' compensation and unemployment insurance systems, which these companies don't have to pay into. Okay, off my soapbox. So not only were these employees not able to get any help from the workers' compensation system, it also meant that the Dodarians were facing a big fine in Rhode Island. I mean, a really big fine a $1 million fine, the largest ever levied against an entity in the state for failing to carry workers' compensation. Rhode Island does not fuck around. Now, that fine was levied against their LLC, Durco, but the state had also just passed a law saying that managers of LLCs, which Jeff and Michael were, can be held personally liable for not having workers' compensation in place. The Dodarians claimed they didn't know they had to have workers' compensation insurance because everyone at the club was only a part time worker. But, well, first, I am sure their insurance agent told them about it. The Dodarians had also told several employees before the fire that they did have workers' compensation coverage, in particular, an employee hired to operate the sound system. One of the brothers told him that, quote, if anything happens to you, you'll be covered by workers' compensation, unquote. And that wasn't the only employee who'd had a similar conversation with the Dodarians. The Dodarians went to court over this, since it was money they might be on the hook for, and after some legal wrangling that went all the way up to the state Supreme Court, they won. The court found the LLC they'd established, Durco LLC, was responsible for obtaining workers' compensation, not the individual brothers. So it was the LLC that needed to be fined, but the LLC was broke, so no money was ever paid out. Those of us in insurance are saying, so that whole piercing the corporate veil thing didn't happen here, but that doesn't mean it never happens. Trust me, it happens. The Dodarians then sued their general liability insurance carrier. The Dodarians argued the insurance carrier should pay for their criminal defense. Anyone who knows anything about general liability insurance knows this was dead in the water before it even got off the ground. Oof, that's a mixed metaphor. The court slapped them down pretty hard, saying, and I quote, a thorough reading of the policy convinces this court that the parties' clear intention when entering into the contract was that Essex would provide the Dodarians with a defense only in civil proceedings in which bodily injury or property damage were alleged. Unlike the alchemists of yore, we do not claim the ability to transmute base metal into gold. Neither can we transmute a 200-count criminal indictment into a civil proceeding. It is our opinion, therefore, that Essex had no duty to defend the plaintiffs in their criminal prosecutions. Unquote. Snap. There was also an issue with the insurance policies for Triton Realty, Raymond Villanova's property company that owned the Station Nightclub building. Triton Realty did have an insurance policy, but the name of the company on the insurance policy was not the name on the lease with the Dodarians. The name on the insurance policy wasn't affiliated with the property owner's company at all. It was just similar. As we say in the insurance industry, the first named insured on the policy was not correct. You might think this was an exceedingly dumb mistake that should have been caught by one of the people who saw the insurance policy at the insurance company, or the property owner when they received a copy of the policy, or the insurance broker who was the intermediary between the property owner and the insurance company, and you would be right. But this is an error that happens more than you might expect. I don't know if it's just laziness or sloppiness or, and here my own experience shows through, the fault of the owner of the property themselves. Really. While sometimes the error is on the part of the insurance company, hey, it happens. In this case, it was all on the insured. If I had a nickel for every time the first named insured on a policy needed to be changed because the insured themselves weren't sure what their actual legal name on the policy should be, well, I'd have some nickels, that's for sure. On big insurance accounts, something like Home Depot, for example, you typically don't have this problem because they're so big, it's almost impossible to ensure that all owned entities are listed on the policy. I mean, they add and subtract things all the time, and they have lots of little entities floating around. As a result, you generally attach an endorsement that provides coverage for all entities owned by that company without having to be specifically listed on that company, subject to certain conditions, of course, because nobody wants to automatically add a named insured to a Home Depot policy that does something new and terrifying to insurance companies, like if the Home Depot started building homes or started branching out into new industries like, say, transporting dangerous chemicals. So, when Triton Realty told their insurance companies, Merchants Insurance Company and CNA Insurance, that they were being sued for the fire at the Station Nightclub, and they shared the lawsuit documents with their insurance company, the insurance companies compared the lawsuit to their policy and said, "Sorry, Charlie, we don't insure the entity listed on this lawsuit. It's not listed on our policy as an insured entity, so you have no available insurance coverage for this lawsuit." And so Triton Realty had to sue their insurance companies to try and get it fixed. And they eventually did. The other problem Triton had was the lease agreement with Durco LLC and the Dodarians. Durco LLC was the company the Dodarians used to run their businesses through. According to the lease, the quote, landlord had no responsibility whatsoever for maintaining the building or keeping it in compliance with building and fire codes, quote, though it went on to say that Triton warranted that the building met all codes when the Dodarians signed the lease. Hint, that was not true. Triton was supposed to be listed as an additional insured on the Durco LLC policy. For non-insurance people, this means that Durco would have to defend Triton and possibly provide insurance coverage in the event of a lawsuit, and I'm sure that Triton was looking to this to pay lawyers' fees and maybe some insurance money. Now, apparently the Dodarians did ask their insurance agent to reach out to their insurance company, Essex Insurance, to make sure this got done, but it never happened. So that's a problem for Triton, and now it's a problem for Durco because, of course, Triton and Triton's insurance company sued Durco over this. It was eventually resolved, but I'm sure it cost Triton and Triton's insurance carrier money to resolve it. I raise both these issues as an example of how mistakes get made in insurance all the time. The other thing I wanted to talk about was the responsibility of the fire inspectors or the insurance company inspectors to have caught the foam during their inspections. Let's start with the fire inspectors first. I am not a fire inspector, but I assume they work off a checklist. And while there are a lot of government workers who go above and beyond, some people do not. I don't know if that's the case here. Was there a checklist item that addressed things attached to the walls or soundproofing? I'm sure there was one about fire extinguishers, which is interesting because after the fire, inspectors were able to go into one room that was still standing, the storeroom. In the room, they found two unused fire extinguishers, but both had inspection dates of 1995. So I do think that someone fell on the job here, but it's unclear where the breakdown happened. Was it the inspector or the process? While West Warwick and the state of Rhode Island both contributed to the settlement, the fact was that unless the lawyers could prove that the inspector deliberately failed in his job duties, the law granted him immunity from prosecution. That's typical and it's probably necessary. Otherwise, these entities would be sued all the time for even little non dangerous mistakes. And of course, no one would want to do the job either. While both books about the event make noises in the general direction of the quote, corrupt, unquote, Rhode Island government and government workers, no solid accusations were ever made against the fire inspector. The inspectors for the insurance companies are another matter. So, their job isn't to determine if the building is safe. Their job is to determine whether or not the building is a good risk for the insurance company. And that means they look at different things. They aren't looking at everything. They're probably only looking at the most important things to the insurance company, a handful of things that drive losses. It's important to note here that very few insurance companies do inspections for general liability policies. The majority are for property related policies. In this case, Essex Insurance did hire an inspection company to do an inspection, and Essex was the liability insurer for the station, so they did do a general liability site inspection. But if the courts held that insurance companies and inspection companies hired by the insurance companies had responsibility here, that would set a precedent that would probably result in a lot of insurance companies no longer writing business in Rhode Island at all. So, not surprisingly, the courts pretty quickly dismissed the claims against the insurance companies and the inspection companies, as the court precedent is pretty clear. These companies were acting on behalf of the insurance companies and not for the safety of the public, and a whole bunch of other super nerdy insurance stuff that's too complicated to discuss here. However, the lawyers for the plaintiffs made noises like they were going to appeal that dismissal. Rather than continue to argue about the situation, the insurance companies offered what was a nominal sum to get out of the case, which the plaintiffs accepted. This is unusual, but signifies how high profile this case was for everyone involved. This was a goodwill move. Another thing that's worth addressing is what happened to that $176 million settlement. You might say, hey, Meredith, you've mentioned a few times before that if a company loses a trial and has to pay a verdict, the amount of money that gets paid is usually different and usually less. And that's true, but this wasn't a verdict, it was a settlement. Because it was a settlement and not a verdict, it's safe to say the insurance companies paid out exactly that amount of money to the settlement fund. We do know that the entire 176 million wasn't directly deposited into the hands of the people affected by the fire, and that's because the lawyers had to get their cut first. So, how much did the lawyers get? John Berlick, the lawyer who wrote the book titled Killer Show, dances around it. It's probably in the 30% range. True, the lawyers did put up a lot of money up front to litigate the case, so that was an expense that needed to be recouped. If we assume the lawyers took 30%, that would put their take somewhere in the range of $52 million, leaving about $120 million remaining for all the claimants. If it was you, how would you then disperse that $120 million? It doesn't seem fair to give everyone the same amount. If you remember my podcast episode about Lloyd's names and the asbestos crisis, you might also remember that the settlement funds in that case used a scale that weighed things like how long you were exposed, what your symptoms were, your age, and that determined how much money you received, assuming there was still money left. For the station fire settlement, a Duke University law professor named Francis E. McGovern was appointed to oversee the distribution of the funds. McGovern was an expert in mass tort claims and had overseen the distribution of funds for several very large settlements, including those involving various medical products like breast implants and the Dalkon Shield, as well as working on the disbursement of money from the Deepwater Horizon disaster. He passed away during the pandemic when he had been working on distributing money from settlements related to the opioid epidemic. McGovern had to decide, with input from the victims, how to distribute the money. They eventually landed on a points-based system. This assigned a base level of points to every victim and then added from there, based on medical bills, the age of minor children, etc. People who were still alive, but very badly injured, received the most money. For the people affected by the station fire, the money didn't fix anything and it didn't make anyone whole again. You could argue that this wasn't enough money, or it was too much, that the entities that paid the most weren't the most responsible. But the bigger picture is this. Did anything change as a result of this fire to prevent future tragedies? The National Institute of Science and Technology, NIST, did a comprehensive review of the fire to determine what went wrong and how things could have been different. This is an enlightening document available online. I'll drop a link in the show notes. Warning, it's huge, and I don't understand all of it, but the beginning and the end are worth reviewing. The highlights. First, what would have changed if Howard Julian and the Dodarians had used fire-resistant foam to soundproof the building? Flame-retardant foam, according to NIST, would not have burned in the conditions at the Station Nightclub. No burning, no fire. Could the foam itself have been made safer by making sure that people knew what type of foam it was and whether it was appropriate for use in a nightclub? Absolutely. Berlick uses the example that the U.S. Navy uses foam in their submarines, and you bet they know where that foam came from and whether or not it's flame retardant. There also has to be some kind of clever way of identifying flame retardant versus other kinds of foams. And there has to be a clever way of identifying the manufacturer of a particular foam. The lawyers argued these things in detail in the lawsuit, and I think they have a point. If these things could make a company money, you'd bet they've figured it out already. It's disappointing that the industry hasn't taken this on as a whole. It might be something that the government has to take on. John Berrylick argues, and pretty convincingly, that lawsuits are currently the only way to make this happen. But the problem is, the companies aren't suffering to pay out. The insurance companies are. And now we're back to the gun control argument that insurance is going to be the thing to fix gun violence. Again, I reiterate, this is also a government issue, and government needs to solve it. How would things have played out if the building had had a fire sprinkler system and the foam had remained the same? According to NIST, if the station had a sprinkler system, even just 3 sprinkler heads directly above the stage, the fire would have been extinguished within 2 minutes. At no time would conditions inside the building have been fatal. The cost of installing sprinklers at the station in 2003? About $39,000. The amount the Dadarians spent to upgrade the sound system in the building? $65,000. It's sobering, right? Outside of the NIST report, I want to touch on 2 things. First, could the insurance companies have identified that the station was an entity they did not want to insure? Well, probably. But there are always new insurance companies willing to take on bad risks. I've said in other episodes that there's a saying in insurance that I can insure anything at the right rate. And I don't agree with that, though lots of insurance people do. One obvious thing you could do as an underwriter would be to ask about pyrotechnic use on the insurance application. Some companies do, and some don't, instead relying on state and national fire codes to make sure pyrotechnics are not used or used only in a safe manner. There was a time in my life when I underwrote entertainment venues and restaurants, and this would have been well after the station fire, and yet I cannot remember whether we asked about fireworks, so clearly it wasn't a hot button issue for those insurance companies. Could the fire inspectors have identified that foam and checked it for flammability? Absolutely. But I'm not sure we can rely on an individual to confirm the total and complete safety of a building, even with a longer checklist. And it would take more people and more money to even attempt to improve the process, and that's something people don't want to pay for. Some things did change as a result of the fire and the NIST investigation. In Rhode Island, sprinklers are now required at every nightclub with an occupancy of over 150 people, no matter when the building was built. They also halted the use of pyrotechnics at venues smaller than 300 people, though I doubt this particular guideline would have saved many lives in the case of the station fire. The National Fire Protection Association changed national requirements for fire sprinklers, requiring them in any nightclub venue with an occupancy of over 100 people. Any new nightclub location requires sprinklers, no matter the occupancy size. They also require more exits and crowd control measures, but enforcement is handled on a state or local basis, so it depends on how much those places decide to enforce it and how many people they have to ensure it gets enforced. So, for example, there's a mismatch between Rhode Island's changes above and the NFPA requirements. Welcome to government. Congress introduced a bill called the Fire Sprinkler Incentive Act in 2003 after the fire that would make installing sprinkler systems more cost-effective via tax credits. But despite it being raised multiple times between 2003 and 2013, nothing happened. The CARES Act added some tax incentives for fire sprinklers during the pandemic, but the act expired in 2021. I mean, this seems like a no-brainer, and I find it frustrating that tax incentives for sprinkler installation are somehow so polarizing. From an insurance versus history standpoint, I think history wins, because nothing insurance could do would make people who suffered in this tragedy whole again. On the other hand, while this was a big verdict for the insurance industry, at the same time, no one entity had to pay for the whole thing, which is a win for insurance. Even so, the individual underwriters probably got raked over the coals at work. What could they have done differently? Nothing, probably. We love to argue in insurance that the potential for loss can be quantified, but to some extent, you just cross your fingers. And yes, this is true, even if you have an actuary running the numbers. The Station Nightclub was never rebuilt. Triton Realty donated the land in 2012 to a nonprofit that erected the Station Fire Memorial Park at the site. In 2016, the game Pokemon Go designated the memorial as a Pokestop, which, as you can imagine, made a lot of people very mad. Apparently, Pokemon Go was a problem at many places, including the Atomic Bomb Memorial Park in Hiroshima and the U.S. Holocaust Museum in D.C. Michael Dadarian was released from prison in 2009. He and Jeff made one major misstep after he was released when they agreed to be speakers about safety in places of public assembly/amusement at a conference. That speech got canceled, and rightly so. In 2013, Michael embarked on a new career in the insurance industry. I kid you not. His company sells life insurance. Guys, I've got nothing. I'll leave all this for you to comment on amongst yourselves. Jeffrey Dadarian never had to do any of those 500 community service hours, but he served his probation and kept a fairly low profile until a few years ago when he dove back into news reporting. He's now a part-time reporter for a local Connecticut TV station. Dan Biacelli was released from prison in 2008. During his incarceration, he wrote personal letters to every family affected by the fire, and as a result, many victims showed support for his parole. He retired from the entertainment industry and lives in Florida. Jack Russell couldn't tour for a while because no one would insure him. These days, he still tours as Jack Russell's Great White, though there was a short period a few years ago where the actual band members got back together to tour as just Great White. That didn't last, and now he's back on his own using hired musicians. He tried to raise money to help those affected by the station fire, but he didn't get a lot of support for this. He did raise some money that was donated to an organization run by survivors. In fact, more money was raised by musicians who were not Great White. Dee Snider of Twisted Sister led a group of musicians, including people from Tesla, Winger, and even country singer John Rich. Dee said publicly, "Nobody deserves to die because they wanted to see a band." Sadly, people still use fireworks in dangerous ways, and concerts continue to have issues with fire safety and crowd control. There have been several deadly fires involving pyrotechnics inside buildings since then, though none on the scale of the station fire. One of the interesting things that the books about this event mentioned was this fire happened before social media took off, and that's partly why it was so hard to raise money for the survivors. In contrast, after the Boston bombing in 2013, $26 million was raised for the victims in less than 2 weeks. A fund called the Station Nightclub Fire Relief Fund raised about $3.27 million and closed after a few years. The Station Fire Fund received about $200,000 from those charity concerts and eventually wound down as well. It does beg the question, if they'd been able to raise more money from individuals up front, would the settlement on the lawsuit have been so large? Probably. I made a conscious decision with this episode not to feature or discuss people who were injured or killed in the fire, as I think some of what I read in researching this episode was frankly exploitive. If you want to learn more about them, I encourage you to go to the website for the Station Fire Memorial. That's a great place to start. I think that the station fire represents an example of how small decisions have big impacts. I do not doubt that there are still buildings like the Station Nightclub open today, buildings without sprinkler systems that could, in the right circumstances, lead to another tragic event. Thanks for listening. Show notes, a list of sources, and additional reading suggestions can be found on my website, which is linked in the show description on your podcast player. If you enjoyed the podcast, please subscribe to the show on your preferred platform to be notified of new episodes as soon as they drop. And let other people know about the podcast by spreading the word. And you can friend me on LinkedIn. I'm always happy to connect. And remember, be safe, be smart, and read your policy wording.